India is known across the globe for its progressive abortion rights that allow women to have control on their bodies and strengthen women's rights. Today, we bring to you the history and evolution of abortion rights in India. Abortion in India has been legal under various circumstances since the introduction of the Medical Termination of Pregnancy, that is MTP Act in 1971. The MTP Act, which allowed registered medical practitioners to carry out abortion under certain specified circumstances, granted immunity to doctors for performing an abortion in accordance with its provisions from the prosecution under 312 IPC. The 1971 law was founded on the principles of the British Act passed by its Parliament in 1967, and it allowed abortion till 20 weeks of pregnancy. Thereafter, the Rajasthan government also passed its own regulations implementing the said act in 1975. The abortion law was briefly amended in 2002 to allow the use of the new medical abortion pills mifepristone and misoprostol. Under the MTP Act, abortion was always allowed till 20 weeks of pregnancy. However, with different cases and situations, the law was amended in 2021 when the abortion limit was pushed to 24 weeks. In 2021, the Kerala High Court denied permission to a couple to abort their 35-week fetus. However, during special cases, including a 2015 case, the Gujarat High Court granted a 14-year-old rape victim to terminate her pregnancy beyond the given limit. The court has asserted that the judgment of the special case could not be used as a precedent to grant permission in other similar cases. The Medical Termination of Pregnancy Amendment Act 2021 came into force with effect on September 24, 2021, after the Rajya Sabha approved the MTP Amendment Bill 2021 on 16 March 2021, which got the President's nod. The bill was approved in Lok Sabha on 17 March 2020. Under the new amendment law, the government set up 7 categories of women who would be eligible for termination of pregnancies between 20 and 24 weeks under Section 3B of the rules. Survivors of sexual assault or rape or incest, minors, change of marital status during the ongoing pregnancy, widowhood and divorce, women with physical disabilities, major disability as per criteria laid down under the Rights of Persons with Disabilities Act 2016, mentally ill women including mental retardation, the fetal malformation that has substantial risk of being incompatible with life, or if the child is born, it may suffer from such physical or mental abnormalities to be seriously handicapped, and women with pregnancy in humanitarian settings or disaster or emergency situations as may be declared by the government. Studies around the world show that women who are forced to carry an unwanted pregnancy to term are more likely to suffer from a range of health and psychological issues such as anxiety, depression, loss of self-esteem, and so forth. They are also more likely not to follow through on their aspirations and to shelf their life plans. Stigmatized by the society, traumatized by their predicament, stripped of their agency, these women probably find themselves pushed to the brink, and it's not an easy ride back from there. It's just another reminder that the country must do all it can to facilitate ease of living for women so that they can lead healthy and economically empowered lives. Access to safe abortion services without the impediment of caveats and veto powers from others is an important part of the effort to enable women to direct the course of their own lives and control on their own bodies. In an empowering judgment recently, India's Supreme Court said a woman whose live-in relationship has ended should be given the same rights to end an unwanted pregnancy as a widowed or a divorced woman in India. India's Apex Court said it would interpret Medical Termination of Pregnancy Act and related rules in such a manner that there is no discrimination between married or unmarried women. India's Apex Court said in a landmark statement, the bench observed, going by the legislative intent, a widow has lost the support of her life partner, and in divorce too, there is loss of support from life partner. This logic will equally apply to a woman who has been abandoned. further strengthening women's rights in the country and extending the same logic to unmarried women, the top court in the significant pro-choice judgment said, for the purpose of a woman's mental health, both actual and foreseeable factors have to be borne in mind. A woman, on being deserted, faces foreseeable difficulties. Such a situation where a woman is abandoned will apply to both married and unmarried women.